Senator Rocky Adams, Senator Chambers Armstrong, Senator Wilson,
Here.
Representative Bridges,
Here.
Representative Gordon, Representative Marzian, Co-Chair West,
Here.
and Chair Lewis.
Here. With a quorum being present, the subcommittee is duly constituted to do business. Before we get into official orders, I do want to wish Tyler Peevler a happy birthday, one of our staffers here. So happy birthday, Tyler. We have a great staff on this subcommittee, and Tyler goes above and beyond to help us every month. We appreciate him. Hey! All right, with that being said, the first matter of business is approval of the minutes last meeting. Are there any additions or corrections to the minutes? Is there a motion for approval? Is there a second? Without objection, so ordered. Please call the first regulation.
Kentucky Higher Education Assistance Authority, 11 KAR 12010, 020, 030, 040, 050, 060, 070, and 090. 11 KAR 12010, 020, 030, 050, and 060 have staff suggested amendments.
This package provides for forms and communications to be submitted to the agency electronically, updates language related to certificates of deposit, clarifies program beneficiary residency requirements, includes that a combination of facts may be considered in determining resident classification, deletes outdated references to program penalties, allows a program participant to adjust the level of benefits distributed in an academic period, and clarifies the availability of unused benefits. The staff suggested amendments amend various sections of the administrative regulations to comply with the drafting requirements of KRS Chapter 13A.
Would you please identify yourself for the record? Make sure that green light's on. Thank you. Try it.
Miles Justice, General Counsel, Kentucky Higher Education Assistance Authority. Thank you for the tip.
Thank you, thank you. There are staff amendments, or is there a motion for approval? Without objection, so ordered. Are there any questions from members of the subcommittee? Seeing none, thank you for coming. Please call the next regulation.
Personnel Cabinet, 101 KAR 120, 140, and 230. 101 KAR 120 and 140 have staff suggested amendments.
101 KR 120 includes amendments that prohibit a cash award for a suggestion that resulted from a documented request from agency leadership, allow an agency an extension of time to determine whether a suggestion warrants a cash award or if a written explanation for the extension is provided, and require the Personnel Cabinet to issue payment for an award within 30 days of final approval and implementation of the suggestion. 101 KR 140 includes amendments that require agencies to calculate workers' compensation premiums each budgetary biennium, references Kentucky workers' compensation law for provision of benefits, clarifies the process of restoring a worker's accumulated leave time, requires agencies to submit all documentation relating to a workers' compensation claim to the Personnel Cabinet as soon as possible, and makes minor technical updates to material incorporated by reference. 101 KR 230 requires the establishment and maintenance of a mediator pool for the purpose of having qualified mediators readily available, clarifies that a mediation may be terminated if all required parties are not in attendance, allows parties to submit a confidential written statement for matters that were referred to mediation by the Personnel Board, clarifies that all communications related to mediation shall be confidential, and prohibits mediation from being recorded, and makes minor technical updates to material incorporated by reference. The staff suggested amendments amend various sections to comply with the drafting requirements of KRS Chapter 13A and make a clarification in material incorporated by reference for consistency with other recently amended administrative regulations.
Thank you all for coming. Please identify yourselves for the record, please.
Alan Hurst, Office of Employee Relations, Personnel Cabinet.
Rose Holbrook, Assistant General Counsel.
Thank you. There are staff amendments. Is there any motion for approval? Is there a second? Without objection, so ordered. Are there any questions from members of the subcommittee? Seeing none, thank you for coming. Please call the next regulation.
Board of Medical Licensure, 201 KAR 9 270. This regulation has an agency amendment.
201 KR 9270, as initially filed, amended provisions to expand exceptions to the required professional standards in specific circumstances and clinical settings, establish duties that may be delegated to a physician assistant, and eliminate physician licensure and education requirements and patient testing requirements no longer required by federal law. The amended after comments version included additional exceptions to the required professional standards for providing care to patients with cancer diagnoses and cancer-related pain and patients receiving palliative care for cancer. Clarified that these patients may receive buprenorphine products for the treatment of pain or any other condition, and made technical corrections to comply with the drafting requirements of KRS Chapter 13A. The proposed agency amendment clarifies that the level of inpatient residential treatment facility excluded from the established standards is criteria established by the American Society of Addiction Medicine, ASAM, and amend Section 3.4 to require a licensee to perform and document a good faith effort instead of best efforts in obtaining a patient's prior medical records.
Please identify yourselves for the record, please.
Good afternoon. I'm Mike Rodman. I'm the Executive Director of the Board.
William Chase Thornberry Jr., President of the Board.
And Leanne Diakoff, General Counsel for the Board.
Thank you all for coming today. There is an agency amendment. Is there questions or discussion on the agency amendment? Seeing none, I would ask for a motion for approval of the agency amendment. Motion. Is there a second? I'll second it. Without objection, so ordered. Okay, so we do have several people signed up to speak on this. We've spoken quite a bit on this on topic, and I know this regulation's been proposed for quite some time now. We do have members with some other obligations, so rather than rehash what happened last committee and other prior discussions, I'm going to give you all 5 minutes to just give an overview of what's happened since last time, and then just a brief overview of what you're doing. At 5 minutes, I'll stop you. For those speaking in an opposition of this regulation, please discuss amongst yourself. I'm going to give you 10 minutes, and then we're going to answer any questions and go from there. Please begin.
Very good. Well, since our last meeting, we did receive comments, additional comments submitted by KaiSam, and the board took those. We took those comments and we presented them to the full board at a special meeting on October 30th. And during that meeting, the board voted to approve the additional amendments that you saw today. So at that point, that's where we're at today. I really appreciate all the work and assistance from your staff. They've been great to work with to help facilitate this. Do you have anything to add, Dr. Thornberry?
Well, I'd like to thank the co-chair, Senator West, and the ranking member, Rocky Adams, for helping us come to work more closely with our addiction specialty colleagues. Well, I'm pleased that we do have these newer amendments to help facilitate the care. Some of the more forward-leaning suggestions we're a little more reserved about. And part of that is just an honorable professional disagreement of the theory of the practice. Part of it has to do with the position of the board. We're obliged, as you know, to look through the lens of public safety. And with harm reduction, it's kind of like allowing the children to play in the front yard, but if they're going to play by the highway, they need direct supervision. And in this case, since we actually have the regulation because there was a problem to begin with, there was some nefarious activity with buprenorphine. And buprenorphine, of course, as we all concur, by itself, it's an excellent and very safe product. However, when it is diverted and it's used in cocktails, that's when it becomes exceedingly dangerous. And we saw that activity with, regretfully, some licensees and some business practices that was consistent with the opioid epidemic. So we feel that certain means and methods are required for us to have the tools to mitigate that so that we don't move back into that type of behavior. And we've left those in place, at least for this time. As you know, this has been a working regulation for 10 years. It's given the legislature exactly what it asked for. We've asked this time to relax many of the regulation, parts of the regulation that can help facilitate care. We've been very judicious. We've had, I think, by my count, over 20 meetings, 4 and 5 hours apiece to look at not only the wording and the phrasing, but all the particulars of this. We've consulted our colleagues from Paducah to Pikeville. We've looked at other states that are in cohort with us. The committee needs to understand that we're not like the majority of the United States. We look a lot like Florida, Tennessee, Indiana, Ohio, West Virginia. We have a substantial problem, and all those states, of course, have tighter regulation and more stringent oversight. We're going to ask the committee to allow us to keep those tools in place for the time being, though, again, we've relaxed a very substantial portion of this. We're here today with our subject matter expert to answer all the committee's questions if as necessary.
Thank you. 3 minutes. Good job. If you want to step away from the table, those in opposition can come forward. Please pull up chairs as needed. There are several of you. Once you are in place, I'll have you each introduce yourselves, and then we'll begin with a 10-minute time limit on it. Thank you. Okay. Please introduce yourselves for the record.
Katrina Nichols, Kentucky physician.
Lori Nation, physician.
Oliver Bennis, family.
Check your mic.
Oliver Bennis, family physician.
Thank you all for coming. Floor is yours. 10 minutes.
I'm Katrina Nichols. I'm a Kentucky physician for over 20 years, and I am board certified in hospice and palliative care and in addiction medicine. And today I speak for myself, and I speak in opposition to these proposed amendments to KAR 9270. I'm not going to repeat what you've heard in the last session. I'm speaking as a hospice and palliative care doctor who specializes in opioid pharmacology and who prescribes opioids, including buprenorphine, for the treatment of severe cancer-related pain. And I'll say we have effective guardrails for safely prescribing opioids in 9260. But this regulation overregulates buprenorphine. And in the current proposed amendments, it also asks for unnecessary and expensive lab testing, urine drug tests, clinic visits, consults, and it's essentially red tape. And it drives up costs to uninsured patients, patients with Medicaid, hospitals, and then ultimately for Kentucky taxpayers. And as a hospice and palliative care doctor, I do appreciate that the board did put in the proposed amendments for an exception for patients under hospice care and for those who are being treated for cancer. However, it is still restricted to just oncologists and palliative care specialists to prescribe to patients with cancer. So for cancer survivors, they are being treated by primary care doctors, surgeons, hospital doctors, other specialists that are integral to the care of them. And so with the way this regulation is in the proposed amendments, those patients would then be forced off of buprenorphine and onto riskier, more dangerous opioids like OxyContin. And so although this was not intentional, this regulation, the way it stands, it can be cruel to patients living with cancer. And so in summary, I just request that you vote against this proposed amendment as it stands. Thank you.
Thank you. My name is Lori Nation, and I'm here as a quadruple board certified physician with approximately 20 years experience in treating patients with opioid use disorder in Kentucky. I have owned multiple treatment facilities, and I have experience working in all levels of care, as well as I've been teaching and mentoring doctors. I have treated patients across the Commonwealth from Paducah to Pikeville. I have seen firsthand the powerful ripple effect of regulations. When I heard the board assert that Kentucky requires different regulations because we are not like other states, I realized it was time for me to speak up. I want to emphasize that Kentucky's physicians possess more experience and are better trained in this field. We have had to adapt quickly as our patients' lives depend on it. This is the reality of practicing medicine in the high-potency opioid era, an era that was ushered in after well-meaning regulations were put in place. In the last meeting, there was testimony that I found difficult to understand completely, so I want to clarify some points. Buprenorphine regulations were put in place 10 years ago, a year when we recorded 1,248 overdose deaths. Last year, Kentucky had 1,410 overdose deaths. This is an increase in deaths. We had a huge spike at the beginning of COVID. Taking credit for decreasing numbers over the last few years without a step back to show the entire picture is grossly misleading. We can be led down any path to a designated end goal. We are told of the dangers, such as the claim that mixing buprenorphine with a cocktail, such as benzodiazepines, can cause a patient to get high. But I'm here to tell you this is a distortion of addiction medicine. If you mix any of your medications with Xanax, you can also feel high, but we should not ban or restrict all medications due to this. Perhaps there should have been more oversight of opioids and benzodiazepines from the beginning, but that is a cat you cannot put back in the bag now. I will continue to treat my patients with the dignity and respect they deserve. They should be treated like any other people with a chronic illness. Let me close by asking you this. Have you ever had to hear testimony from a group of endocrinologists because they were upset the regulations told them what dose of insulin they had to use to start their patients, or how they were supposed to monitor their glucose levels? If not, ask yourself, is addiction medicine being treated like a disease or a moral failing in Kentucky now? Thank you.
Hello, Oliver Bennis, dual board certified family medicine and addiction medicine. I wanted to take this opportunity to briefly explain how these regulations are affecting buprenorphine prescribing practices in Kentucky. The KBML believes that heavy regulation leads to more comfort in prescribing, and I'm here to tell you that is absolutely not the case. In interactions with my family medicine physician friends and colleagues, I have heard over and over that doctors are not comfortable bringing buprenorphine prescribing into their practice because they're afraid for their licenses. They're afraid they're going to do something wrong and get punished. They're afraid of practicing outdated and incorrect medicine. So these regulations cannot pass as is. They are causing harm. Thank you for your time.
Thank you all for your presentation. Do any of our members have any questions or comments for those speaking in opposition? Representative Mary Lou Marzian.
Thank you, Mr. Chair. I know at our last meeting, Chair West asked for the board to come together with you all and work something out. Has any of that happened at all? It seems not, but I know that was a request of the chair.
If I may say, we have.
If you want to come up to the table, introduce yourself, and then turn on the mic. Thank you.
Thank you. I'm Dr. James Murphy. We have a total of 8 people that want to speak, and I have talked to them and asked them to keep it very brief. But if I could allow the committee, they've come here, they've taken their time. Some of them are veterans, and I think that out of deference to the importance of this issue, I would respectfully ask that all of us be allowed to at least give a couple minutes.
You have 3.5 minutes. Well, use it how you want to use it.
Total 3.5 minutes? I have. So am I to understand that you're going to give this subject 3.5 minutes total going forward?
You can question me on this, or you can use it to strengthen your case. Well, it makes no difference to me.
This is an example of the process that this whole thing has been gone under. The medical board, I sat here in the committee meeting last time, and I heard Senator, the co-chair, West, ask the medical board, please look for compromise, meet with the other side, which represents, by the way, a vast majority of people that are in opposition to this, people that are experts in the state, people that take care of people in this state. And I can tell you this, we reached out. Now, I'm on the board of directors of the American Society of Addiction Medicine. I'm also a Louisvillian. I live in this state. I work in this state. I reached out. Dr. Ryan, who is our president, reached out. We were told there will be no meeting. We do not need a meeting. That's what the medical board told us. Instead, they said, submit your recommendations. So we did. We submitted detailed recommendations. 0 discussion, 0 dialogue, 0 getting back together with us, nothing. And then on October 31st, we get notified that they've changed 2 things. If you've seen what they've changed, they changed the word A to the word an. They changed a passage about getting records from best effort to good faith effort. Listen, I understand you want to get through this. I understand this is difficult. I understand that we want to move this on and whatever. But the process has led us to here. And this process has led us to this committee. And based upon the overwhelming evidence and the data and the testimonies, I don't see how this committee could vote to let this go forward. Honestly, I don't see how they could do it. And I would be glad to answer questions, and my colleagues are here to answer more questions. We have distinguished people here. We have plenty of time for this. We've taken off. This is important, and we will answer the questions respectfully and honestly and accurately. We are the experts in this field. We are your neighbors, your friends. We are the people that take care of you. We take care of the people on the medical board. I'm not against them. I want their families to do well too. I'm a Kentuckian just like you. So that's really the most important point I want to make, is that this can't go forward. And if we could let other people speak, I'd appreciate it. If not, I guess we'll just have to hope for the best.
10 seconds to spare. This is part of a process. It's going to be administrative regulations. It's going to go to the committee of jurisdiction at that point. Discuss, should you talk to that chair? I don't know which one I'll go to, whether that's L&O, whether that's health. At this point, I am going to go back to questions, though. My co-chair, Senator West, has a question.
Thank you, Mr. Chairman. Just a quick question. This Dr. Murphy, I think, can handle this. These regs have been in effect for 10 years, and the board says we're relaxing these to an extent. Some of the previous testimony today from people against the regs, it made it sound like we were being more restrictive than where we currently are. Is that your opinion? The impression I got was, here's our current regime. It's been in place for 10 years. We're opening up this regime a little bit to allow it to be less restrictive. But the people speaking against make it sound like it's more restrictive. So if you want to comment on that and just kind of tell me where I'm wrong or if I'm thinking incorrectly on that.
Well, it is incredibly restrictive. It is unusually restrictive in this country. It is an outlier. This regulation sets Kentucky apart. And I can tell you, as a national figure in this field, the eyes of the nation are on this. You saw the paper from the American Medical Association and all the other organizations. This is a big deal. That is incredibly restrictive. The medical board has changed a couple of things and made a couple of things maybe a little bit better, a few things, but they've also added things to it that make it even worse and make it more expensive and create more barriers for people that have this disease process. Listen.
That's what I was talking about. Could you be specific? Like, what have they done to make it worse, I guess? That's what I need to know.
For example, they have added restrictions requirements for drug screens. And they've added specific elements to those drug screens that are expensive and must be run by expensive laboratories. So if I'm a patient that doesn't have insurance or can't afford to pay the co-pays on these expensive lab tests, the regulations require that, and so then I can't. I might be kicked out of the practice. The doctor may not feel comfortable prescribing for me, and these
so
are.
Can I? I'm gonna play devil's advocate. Okay.
Okay.
I'm a layperson. I'm not a medical doctor, right? So I'm gonna, as Senator Givens usually says, respectfully push back. So if you're a doctor and you're prescribing these types of medications, wouldn't a drug test be good for knowing, hey, this person has done heroin or fentanyl in the past week and a half or 2 weeks or whatever? Isn't that, we're talking about addiction, people who are addicted, so wouldn't that be an important tool to make sure that hey, it's just not just a cocktail like the doctor was saying. It's that they haven't fallen off the wagon, so to speak. Isn't that part of their job to kind of look out for the patient as well, to make sure that they're okay, right? And they haven't taken heroin or fentanyl or any other illegal substance along with this medication. Is that a fair assessment? Am I off base there? Or?
Well, I think that the concept can kind of make sense, but let me tell you what that is. A lab test, a drug screen, is simply numbers on a page. Okay, it's just only as good as the confidence we have in that screen. So it might be somebody else's urine, it might be a false positive or a false negative. The important thing is that I'm gathering information as a physician. What I do is I don't just do labs, and I don't just do screening tests and MRIs. I talk to patients. I gather information. And based upon my expertise and my knowledge in the context of your condition, individualized, I'll come up with a plan of care. And I might use a lab test. I might use a drug screen result. I might use the CASPER report. All of these things are helpful. But at the end of the day, this is a life-threatening condition. This is something that if the patient can't do the drug screen, or or even something goes wrong with the lab, I don't have it, I still need to be able to make the decision to give that patient this medication that's life-saving. It's like somebody has got chest pain. If somebody here falls over with chest pain and they pass out, and we bring that external defibrillator over here, I'm not going to try to get a lab on them. I'm going to put the defibrillator on their chest and analyze it and try to save their life. Somebody who comes to you and is getting this life-saving care, you can't have regulations or barriers in place that make them go away or wait a week or all of these things like that. We have to have the ability to use our best judgment in caring for patients. So yes, information from a drug screen might be helpful, but it cannot be mandatory. And that's not just my opinion, Senator. That is the opinion of all of the experts that care about this in this country. The people that own labs, they may not care about that. People that make money off these labs, they may have a different idea about this. But the people that care for people with this life-threatening illness think otherwise.
While there's been arguments going back and forth about this, SAMHSA has actually released different regulations for methadone. So while we are battling these regulations for buprenorphine, they've actually been very lenient for methadone. So Kentucky's adopted the more lenient regulations for methadone, which have been very relaxed. So we're arguing these for buprenorphine, which is actually a much safer medication. And at the same time, we are loosening everything for methadone simultaneously. It doesn't make a lot of sense.
It should not be easier to prescribe OxyContin in this state that causes addiction. It should not be easier to prescribe OxyContin than it is to prescribe buprenorphine that treats addiction. And right now it is. It's much more difficult to prescribe buprenorphine. If you want to talk to your own doctors, go ask one of your doctor. Ask him to look at that regulation and then say, after reading this, would you treat somebody with addiction? I know what the answer will be. It'll be, heck no, I would never do that. Not with that regulation on the books. And the only way you get this medication is not Narcan. You can't get it at the fair. They're not going to give it out in some, they're not going to toss it out to you and say, save lives. You have to have a prescription. It's a Schedule III drug. You can call it in even. It's not even the same level as OxyContin or morphine or things like that. It's a Schedule III drug. It has a low risk with it. It's a very safe medication, but we have to have physicians and PAs and nurse practitioners that are comfortable prescribing it. This regulation blocks that, and everybody knows that. It's obvious. All we're asking is that they do what you asked them to do last time. Send it back. Let's get together and do this right. Don't send it forward again. You have enough information. You should know what the right answer is. And I ask you, on behalf of your families and everybody else in this state who's suffering and dying, for the 4 people who are going to die today from an overdose. Think about those 4 people that every day die of an overdose. Every overdose is preventable. Don't let this go forward. Let us work with them. Make us come together. We can do this right. Other states have done it right. We have the expertise. It's in this room. We can do this. Don't let this go forward. I implore you.
Thank you. Any other questions or comments from members of the committee? You mentioned the right way. So this is a process. You know, you have a Kentucky Board of Medical Licensure that's appointed. We go through the process. We go through this committee. We go through a committee of jurisdiction. We're also going to be back in January in a short time. But this time, this regulation will go forward. Thank you for your testimony. Thank you for your time.
Sir, can I ask for a vote? Can I see who voted for this?
No, we're moving on. Thank you for your testimony. Please call the next regulation.
Just, I have a comment on this.
Please.
For clarification, there is no vote in this committee on any regulation. So if there's no motion for deficiency, a regulation automatically goes through. So the reason he's not responding to a number of votes is there's never a vote on any regulation.
So might understand there's no vote, there's no motion for deficiency? Knowing what you know, there is no motion for deficiency? Zero? All of you?
I'll make a motion.
We do have another question or comment from Representative Marzian.
Thank you, Mr. Chair. I would make a motion for deficiency, and if anybody wants to second that.
Motions or committee stand at ease. Okay, there has been a motion for a finding of deficiency by Representative Marzian. There has been a second by Senator Rocky Adams. The question is on the motion to find the regulation deficient. All those in favor of the finding the regulation deficient will vote aye. Those opposed will vote no. So again, if you want to find the regulation deficient, vote aye. If you're opposed to finding it deficient and think it should move forward, please vote no. Please call the roll.
Senator Rocky Adams, Senator Wilson, Senator Representative Bridges.
I'm going to abstain. I've and explain that, and I've been texting with a local physician on this very thing, and they're not as confident as you are that this physician's in palliative care. So.
Representative Gordon.
I'm going to vote no, but I'm on the health committee, and this is probably the place where it's going to go after this. I had hoped and wished that you all would have met. That's my only comment.
Representative Marzian.
I'm going to vote yes because I'm really disappointed in the lack of communication from the KB, the Board of Medical Licensure. And I have found them to be a little bit obstinate in the past, so I'm going to find it deficient. Thank you.
Senator West.
I'd like to cast my vote and explain.
Please.
I vote no. The main reason I'm voting no is that the Committee of Jurisdiction has the subject matter expertise to cover this particular piece of particular regulation. Although KBML did not meet with the aggrieved parties, I know they have had, it's very unusual, they have had multiple meetings on this subject to discuss it in the past. And this is not their last bite at the apple, so there will be another chance for the opponents of this in the subject matter committee, as well as a legislative session that is coming up. We have 138 members of the General Assembly, and you can ask any of them to file a bill and get it through the legislature, and they can attack this problem for you. So for that reason, I vote no.
And Chair Lewis.
I am also a no. I do appreciate the testimony. I appreciate the passion. I truly do. We do have a process in place, though. I mean, there's often times when a regulation will come through. There was a regulation that came through last year that I didn't particularly agree with, and but I did think that the agency in question had the authority. So we did pass that out of our committee when it came through, and then I filed a bill on it to undo it. So I'm not saying that there's not a path forward here. Again, there is a committee of jurisdiction down the line, but there is a reason for this process that we have in place. And should you think that the committee of jurisdiction gets it wrong, I would reach out, find a bill sponsor, and find somebody that'll be your champion. And you know, once we're debating policy on the floor on both the Senate and the House, maybe your side wins out. But for that reason, I am a no.
With 3 aye votes, we need 5, and the motion fails to carry.
Thank you all for coming. Please call the next regulation.
Thank you for your time. I appreciate it.
Board of Landscape Architects, 201 KAR 10 010, 030, 040, 050, 080, and 090. 201 KAR 10 030, 040, 080, and 090 have staff suggested amendments.
This package prohibits a landscape architect in public service from participating in services that are private landscape architectural projects in exchange for financial or other valuable considerations received from the governmental body or department, requires a licensee to self-report a felony conviction or disciplinary actions imposed by other licensure boards, requires forms and attachments to be submitted electronically, requires proof of successful completion of an examination be submitted for reciprocal licensure, adds requirements related to reinstating or reactivating a license and requesting a retired license, restructures fees related to inactive licenses or the reinstatement of a license, clarifies that only active licensees shall acquire annual continuing education hours, adds new language relating to continuing education requirements for license reinstatement and reactivation applicants, establishes board investigative and disciplinary processes including complaint, review, informal proceeding, and disciplinary processes, and updates material incorporated by reference. The staff suggested amendments amend various sections to comply with the drafting and formatting requirements of KRS Chapter 13A.
Would you please identify yourselves for the record?
Gary Walnut-Zek, board member.
Robert Jones, executive director.
Morgan Rainsdale, board.
Is your mic on?
Morgan Rainsdale, board attorney.
Okay. There are staff amendments. Is there a motion for approval of staff amendments? Is there a second? Without objection, so ordered. Do any members of the subcommittee have any questions or comments? And I don't think anybody's here to speak in opposition of you, so you're free to go. Thank you. Please call the next regulation.
Board of Speech, Language, Pathology, and Audiology, 201 KAR 17120 emergency. This regulation has a staff suggested amendment.
201 KR 17120E amends to update compact rules, including to add the rulemaking on fees. The staff amendment amends Section 2 to include the latest versions of the rules on data system reporting and implementation of criminal background checks and to comply with KRS Chapter 13A.
Would you please identify yourselves for the record?
I'm Sarah Janes, and I'm board counsel for the Board of Speech, Language, Pathology, and Audiology.
Thank you.
I'm Sierra Sherwood. I'm a member of the Speech, Language, Pathology, and Audiology.
Thank you all for coming. There is a staff amendment. Is there a motion for approval of the staff amendment? Is there a second?
Second.
Without objection, so ordered. Any questions or comments from subcommittee members? Seeing none, thank you all for coming. Please call the next regulation.
Thank you so much.
Board of Licensure for Professional Engineers and Land Surveyors, 201 KAR 18040, 060, 081, and 096.
201-18040 through 096 reorganize the fee structure, revise licensure reconsideration, repeal the regulation that required physical licensure display, and establish courses for engineering applicants from the fire protection technology programs.
Would you please identify yourselves for the record?
Kyle Elliott, executive director.
Jake Miller, general counsel.
Thank you all for coming. There are no amendments. Are there any questions from members of the subcommittee? Seeing none, thank you for coming. Please call the next regulation.
Board of Respiratory Care, 201 KAR 29010, 015, 020, 030, 040, 050, and 060. All regulations except 201-29010 have staff suggested amendments.
201 KR 29010 is being amended to update definitions and the material reference. 29015 is being amended to specify that regs are not prorated, that fees are not prorated, and to waive for active duty military members and their spouses the application fee for an initial mandatory certificate to practice by endorsement. 29020 is being amended to update required confidentiality and disclosure provisions, enumerate types of conduct that may be grounds for an application denial, update reporting requirements pertaining to violations of statutory law or regulations, broaden the incompetent and negligent practice provisions in conformity with federal law, and update the definitions and disciplinary action provisions. 29030 is being amended to update definitions, address anonymous complaint and agency-initiated complaints and the criteria to be followed for both, establish a response period for all complaints and service of complaints with default provisions for non-responsiveness, update investigative and probable cause provisions, update disclosure provisions pertaining to open records law, update recusal and remedial action requirements, update notice, hearing, communication, and attendance requirements pertaining to disciplinary hearings, and update the provisions related to costs, fines, and settlement agreements. The staff suggested amendments to 29015, 020, and 030 make changes to comply with the drafting requirements of KRS Chapter 13A.
201 KR 29040 amends to clarify final and agreed orders and admonishments shall not include confidentiality provisions other than as necessary to comply with statute and may be released in response to a request pursuant to statute and authorize release of closing document to the complaining party. 201 KR 2950 amends to clarify the definition of academic courses, add a 1-hour ethics CE requirement to renew, authorize the executive director to approve CE courses in pre-approval and post-attendance contexts, and implement audit processes. Increase the fee for CE pre-approval from $10 to $25, but allow a sponsor seeking multiple course approval the option of an unlimited number of approvals in a year for $100. Specify deadlines for post-attendance approval requests and CE audit responses. Clarify the consequence of a CE audit non-response is disciplinary process, not immediate revocation or licensure denial, and update material incorporated by reference. 201 KR 2960 amends to clarify requests for CE waivers are due on or before the renewal deadline, and the CE requirement includes 1 hour of ethics. The staff amendments for 040, 050, and 60 all make changes to comply with KRS Chapter 13A.
You all been busy.
It's been a long time since we did it. We did it all at once.
Would you please identify yourselves for the record?
I'm Tamara McDaniel. I'm the executive director.
I'm Marlene McKinley. I'm the chairperson of the board.
And Morgan Ransdell, board attorney.
Thank you all for coming. There are staff amendments. Is there a motion for approval of staff amendments? Is there a second? Without objection, so ordered. Any questions from members of the committee? Thank you all for coming. Please call the next regulation.
Department of Fish and Wildlife Resources, 301 KAR 2075, 2172, 2251, and 6070. 301 KAR 2075 and 6070 have staff suggested amendments.
301 KAR 2075 amends requirements pertaining to wildlife rehabilitation, including rabies surveillance and authorization of rehabilitation volunteers. The amended after comments version amends requirements relating to the deadline extension in veterinarian licensing. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
301-172 amends which county-wide areas are deer hunting zones. 251 extends the season for trapping fur bears with water sets, updates IDs, revises the process for CITES tags, and deletes incorporated material. 6070 makes technical corrections and updates incorporated material. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourselves for the record?
Jenny Gilbert, Legislative Liaison.
Stephen Fields, Staff Attorney.
Thank you all for coming. There are staff amendments. Is there a motion for approval? Without objection, so ordered. Any questions from members of the committee? I just have one. It's off topic to this. I was hunting earlier this weekend, and I saw several posts on when I got home on Facebook about possible EHD, and then I know we have had cases of CWD, one particularly close to me in Pulaski County. When do we have any dates that there'll be a release on any findings after hunting season of those deer tested?
So EHD hopefully is you'll see those cases go down. That was really brought on more by the drought that we had. The midges were just worse in those areas where there was standing water, but nothing moving. So I think you'll see those go down. Obviously, I'm not the vet, so I can get you some more numbers on that. But CWD in Pulaski County is something we are watching very closely. Obviously, that case just came through, so we are waiting to have our next commission meeting, and we will set a public hearing or a public meeting in that area before any changes are made to the hunting zone around that area as well. So all that will happen, and we'll notify the public. There's a CWD response plan that we have on our website right now. I'm sure you're familiar with that, but it has been updated a little bit. We're still working on that. It's really a living document because we're finding more out about this as it continues to happen within the state. So it's not just we're not just looking at Pulaski County, we're looking at the other two places, and the response that we had there, the public response and the public help that we had, which was really beneficial because it allowed us to kind of test, and what we're looking for is prevalence, which we don't have unless the hunters turn those specimens in for testing.
Sure.
So we are asking them to do that. Even though there aren't restrictions near Pulaski County right now, we are asking them to still send those in for testing if they are agreeable to that.
Thank you. Any other questions from members? Seeing none, thank you for coming. Please call the next regulation.
Department of Criminal Justice Training, 503 KAR 5140. This regulation has a staff suggested amendment.
This regulation establishes the qualifications and duties of the clinical program director, the curriculum and programming, peer qualifications, and participant requirements for the Kentucky Post-Critical Incident Seminar. The staff amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A.
Would you please identify yourselves for the record?
Good afternoon. My name is Nathan Goins. I'm Assistant General Counsel at the Justice and Public Safety Cabinet.
I'm Andy Wilson, a supervisor at the Department of Criminal Justice Training.
Thank you all for coming. There is a staff amendment. Is there a motion for approval of the staff amendment? Is there a second? Without objection, so ordered. Any questions from members of the subcommittee? Seeing none, thank you all for coming.
Thank you.
Please call the next regulation.
Board of Education, 701 KAR 5170 emergency, and 704 KAR 3440. 704 KAR 3440 has a staff suggested amendment.
701-5170 emergency establishes procedures and material incorporated by reference for processing requests to waive statutes or administrative regulations pursuant to KRS 156-161. 704-3440 is being amended to reflect statutory and regulatory language. The staff suggested amendment amends Section 3 to comply with the drafting requirements of KRS Chapter 13A.
Good to see you, Todd, but that being said, please identify yourself for the record.
Thank you. Todd Allen, Deputy Commissioner, General Counsel for the Department of Education and State Board of Education.
Thank you. There is a staff amendment. Is there a motion for approval? Is there a second? Without objection, so ordered. Any questions from members of the committee? Thank you for coming.
Thank you.
Please call the next regulation.
Kentucky Fire Commission, 739 KAR 2015.
739-2015 establishes training hours for firefighter basic 1 and 2 certification.
Would you please identify yourselves for the record?
Bruce Roberts, Director of Fire Commission.
John Wood, outside counsel for the Kentucky Fire Commission.
Thank you all for coming. There are no amendments. Are there any questions from members of the subcommittee? Seeing none, thank you for coming.
Thank you.
Please call the next regulation.
Department of Workplace Standards, 803 KAR 2120 and 2310.
803-2120 amends to establish that each citation shall not be issued more than 6 months after any alleged violation. 2310 updates to federal requirements in lieu of Kentucky-specific standards and deletes incorporated material.
Would you please identify yourselves for the record?
Chuck Stribling, Deputy Commissioner, Department of Workforce Standards. Good afternoon.
Good afternoon. Jason Hernandez, Deputy General Counsel for the Education Labor Cabinet.
Good afternoon. Robin Maples, OSH Standards Specialist for the Department of Workplace Standards.
Good afternoon to you all, too. No amendments on these. Are there any questions from members of the subcommittee? Thank you for coming. Please call the next regulation.
Cabinet for Health and Family Services, Office of the Inspector General, 900 KAR 5020 and 6075. 900 KAR 5020 has an agency amendment, and 900 KAR 6075 has a staff suggested amendment.
900 KR 5020, as initially filed, amended material incorporated by reference to define pediatric teaching hospital, allow the construction of a pediatric teaching hospital and establish criteria for new acute care hospitals that are pediatric teaching hospitals, allow 4 Level 2 special care neonatal beds in specific circumstances, grant non-substantive review status to Certificate of Need applications submitted by acute care hospitals that propose to convert existing acute care beds to pediatric psychiatric beds at pediatric teaching hospitals, and alter provisions relating to the ownership of ambulatory surgical centers. The amended after comments version amended material to allow exceptions for the establishment of a new acute care hospital in specific circumstances, allow an increase in the number of beds at an existing intermediate care facility for individuals with an intellectual disability in specific circumstances, and make technical corrections. The proposed agency amendment amends material incorporated by reference to revise ophthalmologist requirements in the state health plan. 900 KR 6075, as initially filed, amended provisions to grant non-substantive review status to the following types of Certificate of Need CON applications: proposals for new pediatric teaching hospitals, proposals for an existing provider of a Level 2 service to establish a Level 2 program with 4 special care neonatal beds, and proposals to establish a comprehensive cardiac catheterization service if the applicant is under common ownership with an existing provider within the same county. The amended after comments version removed language that granted Certificate of Need non-substantive review status to a proposal for an existing provider of a Level 2 service to establish 4 special care neonatal beds, and removed a sunset date and other provisions related to ambulance services for consistency with recently passed legislation. The staff suggested amendment amends sections 1 and 2 to comply with the drafting requirements of KRS Chapter 13A.
Thank you all for coming. Would you please identify yourselves for the record?
Valerie Moore, Policy Specialist, Office of Inspector General.
And hi, excuse me, I'm Wesley Duke. I'm the General Counsel to the Cabinet.
Thank you all for coming today. There is a staff amendment. Is there a motion for approval of the staff amendment? Is there a second? Without objections, so ordered. There is also an agency amendment. Are there any questions or discussion on the agency amendment? Seeing none, is there a motion? Without objections, so ordered. Any questions from members of the committee?
I have a question.
Co-Chair West.
Thank you, Mr. Chairman. My question relates to ophthalmology and the changes in the state health plan. There's been a lot of discussion on our side, back and forth with some individuals on this. Could you just give a brief overview, like a 1-minute overview on what that is doing and how it's opening that up a little bit?
Yeah, I'll actually try to be briefer than that. So we had the language that amended the section in regard to the ambulatory surgical centers and the practice of ophthalmology and the surgeries. That was filed. We received a number of comments on that from a number of different types of providers and provider groups. None of them were positive. They felt there were some issues there. No issues with making sure that there's access to care and access to practice, but issues with oversight and making sure that the care being provided was as safe and as effective as possible. So with that being in mind, we received all our comments, and we're going to go back to the drawing board there on that and see if we can't streamline that and continue to work on that to make the access even better.
Quick follow-up to that. So from my perspective, as previous presentation, I'm a layperson, so I'm not a medical doctor, but I do know that our people need care, right? And when they need it when they need it. They need emergent care. So there had been some talk with certain providers of if you're doing an emergency eye surgery, they just want to make sure that they have operating room space where they're able to operate and take care of that person in a timely manner. are you telling me that is somewhat taken care of through this reg, or is that what you're going back to the drawing board with to try to take care of that issue, or help me figure that out?
No, absolutely. No, I think as far as where we are right now, I don't think that as it stands, as far as access to facilities, I know that there's some conversations going on out there among the state with the providers who do have access. Who have this space and making it available to the people who need it. So I know those conversations are going on. What we need to do is go back and see what we can do as a cabinet to facilitate that. And I think at this point, what we did, obviously with the comments that came out, we may have not gone down the right path on that, but we are going to continue to do that to facilitate that conversation and try and expand that access to care. Because you're right, there's no doubt about it, access to those facilities is an issue.
And I'm sorry to beat a dead horse, Mr. Chairman, but I think we're on the same page, and I think that we're thinking the same way. Let's say that you have a problem in a certain area where access to operating space, does the change in regulation to the health plan allow an entity, if that opportunity is not there, does it allow them the opportunity to set up a space within CON and operate a facility just specializing in eye surgery, that sort of thing?
At this time, they can proceed through the CON process to do that. What we would like to do is to take steps to make that easier to do.
Sounds
more
good
opportunities.
Sounds good to me. That's we got to the same place. It's a little confusing to me, so I'm just trying to make sure I'm thinking correctly.
Absolutely.
Any other questions or comments from members of the committee? Just have one comment. Thank you all. I reached out. Stack and I, Dr. Stack and I have, and my co-chair, we have monthly conversations, and you all were very easy to work with. I know that's not always the case. The state health plan can be a bear. I see Marie Cole in the back over there. But anyway, no, appreciate you all, and thank you. If there's no other questions, yes, go ahead.
I have one comment, Chairman Lewis. So I know on that conversation that we had, you had raised an issue in regard to the megavoltage and the MRI. We have since spoken with the industry groups who suggested that change. They want to withdraw that change. We got that information a little late to get it kind of properly here before us today, but we are going to be taking a look at that. So I wanted to take this opportunity to follow up with you because it did come up in our call.
Thank you. Please call the next regulation.
Continuing under Office of the Inspector General, 902 KAR 55015 Emergency. This regulation has an agency amendment.
902-55015 Emergency adds bromazolam to the list of Schedule I controlled substances. The proposed agency amendment adds 7-hydroxymitragynine concentrated at a level above 400 parts per million to the list of Schedule I substances.
Would you please identify yourselves for the record?
Julie Brooks, Policy Specialist for the Kentucky Department for Public Health.
Tim Anderson, Assistant Director, Office of Inspector General, Division of Audits and Investigations.
Thank you. There is a staff amendment. Is there a motion for approval of the staff? Is there, without objection, so ordered. There is also an agency amendment. Is there a motion for approval of the agency amendment? Without objection, so ordered. Okay, where we are short on time, we're going to do the same thing. If you all want to just give 10 minutes to 5 minutes to present what this regulation is doing, and then I know there are some members here to speak in opposition or want to give a comment, and we'll give them 10 minutes. If you want to get overview. Please.
Absolutely, and I'll let Julie and my folks here fill me in the holes I missed. So, no, we took this action in one. You have bromazomam. I hope I'm saying that correctly. Obviously, these are substances that occur outside of any regulation or any issue or any oversight, and so we identified that as an issue that needed to be addressed. So we took the issue, took the steps to schedule it, and that was some time ago. And of course, here we are at committee here today on the emergency regulation, and we saw an opportunity in regard to 7OH, which is the way it is which has been addressed by the FDA as a substance that needs to be scheduled, and many states have taken the step of going to do that. It is done at the level, and as is written today, that is a level that does not occur naturally in legal kratom or kratom, however you want to say it. I always get it one way or the other. So this is something that happens outside of that. So we saw this opportunity now, to take this action and to take it quickly, to fall in line with some of the federal guidance and some of the things our other states are doing, including our neighbors to the north, Ohio. And that is what has brought us here today. And I'll turn now over to Julie and the DPH staff to kind of fill in the holes there.
I'm not really sure how much more I can say. As Wes said, 7-OH or 7-hydroxymetrazonine naturally occurs in kratom, but it's at a low level. This would actually be in line with the level that was established in House Bill 293 from the 24 session, which would be 7-OH at 2%, or allow 7-OH less than 2%. When you get above that 2%, it's a synthetic product that has potential to cause harm.
Highly addictive.
Thank you. Yeah. In my own reading and studying after our conversations, I was actually pretty shocked. But before I give any comments, I'll open it up to any members that have any questions or comments. Co-Chair West.
Thank you, Mr. Chair. Still trying to catch a lot of medical stuff today. I'm still trying to catch up a little bit. Part of what if you're a layperson, you hear things like this side says this and the other side says this. So it comes down to a matter of who do you believe, right? What do you believe? So I've heard that you have regular kratom. Mm-hmm. This is a derivative 7-OH, a different version of that. So some of the pushback I've heard is that the kratom may be more dangerous than this 7-OH. Could you comment? Is that true? Could you comment on that? And do you know what?
Honestly, I'm not sure. I know that kratom is a plant from Southeast Asia, so it's a natural plant that's been used in that area of the world for a long time. What we're finding, though, is that the 7-OH, as I said, it's naturally occurring. It is part of the plant. However, it has been synthesized to where it, the best analogy I can draw is hemp and the cannabinoids that come from that.
Yes, I totally understand it, what you're saying. So, thank you.
Okay.
Any other questions from members? I just have one. So this is just 7-OH that we're talking about, not kratom, however we want to pronounce it, right. The wide spectrum, right?
That is correct, yes.
Okay, thank you. With that being said, we do have a few people signed up to speak. If you all want to vacate the table, and those that have signed up to speak would come forward, please. Please identify yourselves for the record, and then the floor is yours. Again, we're going to put a 10-minute window on this.
Good afternoon, Mr. Chairman Lewis, Co-Chairman West, members of the committee. My name is Jeff Smith. I'm Policy Director for HART, the Holistic Alternative Recovery Trust. We're a national nonprofit focused on research and advocacy that works to address the nation's opioid addiction crisis. First of all, thank you very much for giving us the chance to speak with you today. We were disappointed with the emergency scheduling, which precluded us from making public comment, so we're glad to be able to weigh in today. In 2023, the United States recorded over 100,000 overdose deaths, most involving fentanyl. That's over 300 every day. It's the #1 cause of death among 18 to 45-year-olds. We need new tools to address this crisis, and we believe, based on a voluminous amount of scientific research, that 7-OH is a very promising option. As was stated by the previous witness, the kratom plant has been around for centuries, and the kratom plant contains 7-OH in small quantities. They were talking about 7-OH as being synthetic, but it is a natural element, a natural alkaloid of the kratom plant. The only way that the process of manufacturing it as synthetic is the exact same way that your vitamin C tablet, if you take vitamin C in the morning, or a vitamin C gummy, is synthetic. Instead of eating 25 oranges, you can get the same amount of vitamin C by taking it in a tablet or a gummy. And that's the exact same way and process that 7-OH is produced. According to growing scientific evidence, it is a substitute for dangerous opioids in cases of people trying to manage chronic pain. And we're going to hear from one in a few minutes here, without the respiratory depressant effect of opioids. Okay, when you take heroin or fentanyl, it can have, again, this respiratory depressant effect because it is a full agonist on the mu opioid receptor. So it basically captures that opioid receptor. 7-OH, however, is only a partial agonist, and so it does not produce, in studies, that respiratory depressant effect. So there is no lethal dose in mice that have been identified, whereas there is a lethal dose even of Tylenol if you're using mice in a clinical model. So the chart of fatal fentanyl overdoses, if you look at it over the last 25 years, starting in 1998, it goes up every single year, okay, from 1998 till 2023. And in 2024, something pretty interesting happens. It drops, and not just by a little bit. It dropped 27% nationally, the number of fatal opioid overdoses. So what happened? Well, if you trace the CDC data month by month, you can see that the number of fatal overdoses peaked in August 2023, and then September 2023 was the month that 7-OH became available. Okay, so it's too soon to definitively state that there's a causal impact there, but it is a very interesting correlation that the number of fatal overdoses has dropped every month since 7-OH became publicly available just over 2 years ago. A second, I think, compelling bit of information is that in states, there are a few states that have banned 7-OH, and in those states that have enforced that 7-OH ban, you have not seen that drop in fatal overdoses in 2024. States like Utah and Arizona, you saw a continued increase or a plateau of fatal overdoses, whereas states that had the highest per capita consumption of 7-OH, like Florida, West Virginia, and Virginia, saw reductions in fatal overdoses from 31 to 42%. So reductions far greater than the national average. So again, we think that's pretty compelling. In consumer surveys, a substantial percentage of those who take 7-OH say that they report using it to relieve opioid withdrawal or to manage chronic pain without resorting to heroin, fentanyl, oxy in the first place. And this emergency scheduling would turn those people into criminals. It would endanger people, especially those who are trying to kick opioid addiction without access to medication-assisted treatment. It would turn them into criminals. And since programs like that are rare in rural areas, it would especially be detrimental to rural Kentuckians who are trying to get off these more dangerous opioids. And they would be forced to seek relief on the black market, where oftentimes powders or tablets are going to be laced with things that are much more dangerous than 7-OH. So you're probably wondering, the public health officials that you just heard from kind of alluded to it being dangerous. So I want to just share with you data from the FDA itself. Okay, after over 1 billion servings around the country in the last 2 years, there are 47 adverse events listed in the FDA's database. 47. So that's 1 in 21 million. And some of those adverse events are things like, and I'm quoting directly here, irritability or a euphoric mood. So there are 5 deaths where 7-OH is present in the person's system, according to the FDA database. In all 5 of those cases, they're polydrug scenarios. So you see an excessive amount of, benzos, heroin, fentanyl, other things in their system. So there's not a single case that is directly attributed to 7-OH. And again, for a plane crash, your 1 in 13.7 million is your likelihood of dying in a plane crash. For 7-OH, based on the FDA's own data, you're 1 in 21 million likely to have an adverse event, even adverse events like irritability. The most common side effect, adverse effect that people report in consumer surveys is gastrointestinal discomfort. And I will take that any day over someone dying of a fentanyl overdose. With overdose rates still far too high in this country, we cannot afford to take away a life-saving option. Regulation and not prohibition is the answer. We are hoping that the legislature will respond to this. We are not a group that supports unfettered access. We believe that minors should not access this and that you shouldn't be able to walk into a gas station or a convenience store and get it. And so we would support a ban on any establishment that allows minors in from being able to sell it. We would support third-party testing, labeling restrictions to make sure that you can't have animated characters on it with appropriate warnings, but we should not be denying people this promising, potentially life-saving option. Thank you so much. Happy to take any questions.
Thank you. Any questions from members of the subcommittee? Seeing none, thank you for coming. If the cabinet would come back up, I know I'm going to open it up for questions one more time. You've got a couple minutes left if you would like to testify.
Yes, my name's Eric Lincoln Hoker. I'm 50 years old and I live in Belfry, Kentucky with my wife and 3 sons. I'm a United States Army veteran and a disabled retired locomotive engineer from the railroad. With PTSD from my military service and major physical injuries from a train accident that required 3 knee surgeries, 2 shoulder and a back, I was introduced to the world of opiates and they soon became a problem. I found myself facing legal issues as a result of my addiction. I was able to participate in a program called Veterans Drug Court. It was a much needed second chance. Now sober, I still had the issues of physical and mental pain to deal with. When I discovered 7-OH, I was distraught and probably only minutes away from a relapse. When I tell you that 7-OH is a miracle, I mean that wholeheartedly. It lessened my overwhelming desire to use opiates by eliminating the pain that was telling me I needed them. It reduced my pain to a level that isn't screaming for relief. I understand that y'all have to wear many different hats and are asked to make decisions that you feel are in the public's best interest. But one thing I know is what being high on dangerous drugs is like. And 7-OH is not that at all. Not even a little bit. There is zero impairment. I'm able to participate in life again. For about a year, I take 4 to 5 low milligram tablets a day. They cost 80 cents a piece. That's $4 a day or $120 a month. There aren't many drug prescriptions that are cheaper than that. 7-OH is cheap and effective. It does not cause respiratory depression, which he talked about. It's a compound found in the kratom leaf. Doesn't that make kratom a precursor to 7-OH? What happened to cold medicine when it was discovered that people were making meth from it? It was labeled a precursor and a whole database was created to limit how much could be purchased. 9 grams per ID per month. Kentucky recently raised its annual purchase limit to 86.4 grams. But an emergency ban on 7-OH? How about a compromise? Let's stop the emergency ban. Let's set a legal age limit on it, right along with our beloved bourbon. Put a limit on how much can be purchased per month per ID holder. Put it behind the locked cases. Do these very basic restrictions allow us the time to do the proper research? Let the truth be told. Because there is supporting research that is beginning to emerge that 7-OH is most likely responsible for the recent decline in overdose deaths, which he talked about. Thank you.
Thank you, sir, and thank you for your service. Again, as you point out, oftentimes we do have to make hard decisions in this committee, and like I said earlier in the previous presenter, there is a process, and we follow the process to the best of our ability. But thank you for your testimony. If the cabinet would come back up, I think we do have a few questions for you all.
If the committee would allow, of course, we've got Mr. Van Ingram here who's going to join us for this time, if that's okay.
No, absolutely. Co-Chair West.
Before I ask my question, this is an odd request of the chair. Mr. Chair, I would ask if Mr. Ingram would give us his opinion on.
Absolutely.
You know a little bit about illicit substances and what they are, correct?
Yes, sir. My name is Van Ingram. I'm Executive Director of the Kentucky Office of Drug Control Policy. Starting my 21st year with that agency this month.
Over the last several months, not a week goes by that I don't get 2 or 3 calls from a Kentuckian saying my husband, my wife, my son, my daughter, my brother, my sister is addicted to 7-OH. They're buying it at a gas station. They're spending a lot of money on it. They don't cause adverse impact to their life. I get the question all the time, what are y'all going to do something about this? When I read, it's 13 times more powerful than morphine. And you don't need a doctor, you don't need a nurse practitioner, you don't need a pharmacist. Just a retail clerk at a gas station can sell it to you. I just feel like this is something we're going to have to deal with. Now, they've made some suggestions about regulation, but right now there is no regulation. It's wide open. It does produce euphoria in large doses, so we're introducing people who maybe wouldn't get a prescription for an opioid or wouldn't take heroin or fentanyl, but we're introducing them to that euphoric effect. I feel like the time is here that we must do something with this drug. We've made the compromise of allowing kratom to stay on shelf in its natural occurring amounts. But it seems like every year there's a manufacturer somewhere creating something that mimics the effect of an illegitimate drug, but chemically is not the same. So they can sell it and make money off of Kentuckians. I'll leave it at that, Chairman West.
Thank you. Got a couple questions anybody can answer who wants to. First one, could you respond to the opponents? What data did you use to show that this is a dangerous substance? You know, they spoke of the data from the FDA and those sorts of things. So what data?
The FDA does has it listed as a drug of concern. Mm-hmm. There is a number of web articles about it. It's stuff. If you could Google 7-OH, there's lots to read out there.
And we also used information from the Drug Enforcement Agency, the Centers for Disease Control, and the Mayo Clinic in coming to this emergency agency amendment.
Second question, you led right into my second question, is on process and procedure. Mm-hmm. I know this has been going on for a long time. This is not it didn't happen last week, right? So why did we not just do an ordinary reg, let it go through that process where you would have the opportunity for public comment? You know, why did we have to do an agency amendment?
Excuse me, Senator, I can speak to that. Well, one, I think as was said earlier by Mr. Ingram, I mean, this is we've identified this as such a critical problem, something so strong, completely with no guidance whatsoever from any medical professional that a citizen can access it, that it's reached the level, and the fact that it's been identified as a drug of great concern. We saw an opportunity to act quickly and act decisively, and we took advantage of the opportunity.
I think it's important also to note there are 3 medications that have been approved by the FDA and are evidence-based to treat opioid use disorder.
Gotcha. Thank you. Appreciate it.
And to the process, there is an ordinary regulation that is still in the public comment period. And so we are directing the calls and the correspondence that we get to make a public comment on the ordinary regulation. So it will come back through.
Thank you.
Any other questions from members of the subcommittee? I'll just make a comment, or actually a question. Bromazepam, right? Yes. Is that a drug analog?
So that's a cousin of alprazolam, or we talked about benzodiazepines a while ago. Mm-hmm. This drug was developed many years ago, never was cleared through FDA for a trial, and it just started showing up in northern Kentucky and other places just in the last year or so. So that's why the move to do that. It was developed along with alprazolam as a substitute, but it was never approved.
Is it a federal analog?
Yes.
So under our current law, would we need to go this route with regs? And the only reason I bring this up is that's something that I've been looking into as well on analogs and having got into the federal standard. And in my research on it, I think it already does.
I think this just makes it more clear for law enforcement that they can make an arrest and that type of thing for the sale of this substance.
Okay. I might have more conversations for you, but I appreciate you. Please call the next one. I apologize, guys. We had not approved the agency amendment. Any questions or discussion on the agency amendment? Seeing none, is there a motion for approval of the agency amendment? Is there a second? Without objection, so ordered. Any other questions, comments, concerns? Thank you for coming. Please call the next regulation.
Department for Medicaid Services, 907 KAR 3320, emergency.
907-3320 emergency establishes the Beneficiary Advisory Council and establishes additional requirements for Advisory Council for medical assistance.
Jonathan, I apologize, last on the agenda, man, but please identify yourself for the record.
Good afternoon, Jonathan Scott, Chief Legislative and Regulatory Officer, Department for Medicaid Services.
Thanks, man. There are no amendments on this regulation. Any questions from members of the subcommittee? Thank you for coming. That is the end of the November agenda.
Currently, our meeting is scheduled for Tuesday, December 9th. However, we are looking at possibly moving it. Right now, we were looking at the 8th. So please stay tuned. And we would appreciate communicating back and forth once we get something figured out.
Could anybody check, does anybody know of any conflict with this date and time? Again, that is December the 8th. If so, get with staff and we'll come up with a quorum check. But the meeting is now adjourned. Thank you.